Hi, I'm Audrey DeMarsico. I'm an estates lawyer at Nelligan Law, and this is Manuela Fontana, our estates clerk. Today, we'd like to discuss wills, powers of attorney, and advanced care planning. We'll give a brief overview of each of those topics and then dive into details of why it's important to have a will, to decide what's going to happen to your belongings after you pass on, why it's important to specify who will be able to make decisions for you if you're unwell and incapable of making decisions for yourself, and the benefits of planning in advance or giving guidelines to those people who are appointed to make decisions about your medical care.
How about you start explaining what a will is?
Okay, well, a will is a binding legal document that specifies who will inherit your belongings after you pass on, who will administer your estate, so as in the person who will help to implement your wishes. It can specify also trusts for your children or grandchildren for the future. And you can also use it to plan for your pets in advance, who will care for your pets, leave sums of money to care for your pets. And really, it can be as detailed as you want, or you can have a simple one to have a baseline to start, because it is better to have some will than nothing at all.
And many clients ask, what is the meaning of state? What is a state? And what is an estate trustee? Because we say these words a lot, state and estate trustee. So what do they mean?
An estate is like the whole of your belongings. It's like the envelope of all your possessions. The estate trustee is also sometimes called an executor, and it's the person who is responsible for administering those belongings and either, depending on what you specify in your will, either distributing those to the beneficiaries or maintaining them, investing them for the benefit of the beneficiaries for the future.
And to draft a will, do they have to have capacity?
Yes.
How does that work?
So it's an interesting question, because it's true that we do sometimes get calls from the family members of people who are in the hospital who say, oh, we need a will right away. It's really better not to leave it until it's very late, because if a person is very unwell, they may not be able to make those decisions in a way that will satisfy everyone, that they knew what they were doing. So in order to still have the capacity to prepare that will, then, and not have it contested later by, for example, somebody who got left out or didn't get as much as they would have in an earlier will, in order to have that capacity, you have to have an understanding. What do you own? What are all the things that you need to provide for? Who are all the people who could expect to benefit? Who are the people? What's the identity of the people who might have an interest in your estate, or who might be able to serve as that executor / trustee of your estate?
When clients call during an intake call, they ask about themselves writing their own wills. What do you think about that?
It is possible to write your own will, as long as it's only handwritten. It's not on a typewriter or computer. It's handwritten, and you signed it at the end. And ideally, you should put a date as well, so people know that it was your last will. It's not ideal. We don't recommend that, because ideally, if you have a lawyer help you to prepare the will, they will know all the questions to ask. They will understand the language that the courts will accept and that the courts will find is clear enough. And then they will think about, like, well, what happens in different scenarios? So, for example, you might have a good idea that, if you have a small family, it's the immediate family that will inherit everything. But what if? There are some what ifs. They could be uncomfortable to think about, but once you work through those scenarios, it can give you great peace of mind. So what if somebody passes away at the same time as you or right before you? Then what will happen to that person's share? What if everybody's together in an earthquake? Is there a charity that could be the backup plan? What if your first choice for a trustee is somebody who's very good with property, but would not be a good guardian for your children. Maybe you want a different person to be the guardian for your children from the trustee for the property. So there are a lot of questions that lawyers can help you work through. So it is really helpful to come to a lawyer to get a formal will done. But if you, for some reason, you can't get to a lawyer and you need to know that you have a will, then it's better to do a handwritten one than nothing. And that will be enforced if that's the last will that you wrote and it has your signature.
I think it's important to mention the consequences of having nothing.
Mm.
What happens if a person dies without a will?
Well, there are some options depending on what your family situation is. If you're married, then your spouse will get the first $350,000. If you have close family, they will inherit. If you don't have any family, at the end of the day, it could all go to the government if there's nobody else that has an interest in your estate. So it is better to have a will, because you might decide that rather than just have all of your money or your house or your car just go to the government, then you would like a specific charity to have it, or a friend. Sometimes people come in and they say, well, I just have a friend, and the friend is going to take care of my dog, and I want that friend to have my money and to pay for the dog's care. And it's nice to at least know that if somebody you know who's going to benefit from it, instead of it just going and being held in the office of the public guardian and trustee of the provincial government for years, and not knowing that anybody is going to get any benefit from it at all.
And I think it's important to mention as well that the administrative part, if a person dies without a will, the person has no representative. So there's no person, let's say, pay the rent, deal with the house, deal with the pets if they have pets, deal with utilities, simple things. But once the person dies, somebody has to deal with that. So if the person has a will, the executor or the estate trustee can get the will, go to the bank, deal with all that, the financial aspect of the deceased life, can get the will probated, get the certificate of appointment, and start managing the affairs in a quicker way than if there's no will.
It's true, because it can take a long time for the court to grant a certificate of appointment of a state trustee. But even while you're waiting for the court to review the application, and this can take months, while you're waiting, if you have a will and you can show the bank, but I am named in the will as a trustee, it just hasn't been formally recognized by the court yet, then they usually let you access the deceased's account to pay for funeral expenses. For example, they can give you a money order to pay for the funeral expenses. If there's no will, then often people cannot do anything, and sometimes it's very difficult, because if your closest family is not in the same province as you, they will fly here and they will try to cancel your lease, your subscriptions, and nobody will deal with them. Nobody will talk to them. They can't do anything, and it's very frustrating. So to have that will to actually name someone, it will at least get people like the landlord to listen to them. If they say, no, I want to cancel the lease, I don't want this rent to continue to be paid for months while we go to court to appoint a trustee.
Audrey, let's explain what is a power of attorney.
So the word attorney means representative. I know in the United States people use it to mean lawyer. We don't use it that way in Canada. But it's the same idea. Like, this just means a representative. And a power of attorney is really a document that gives that representative powers to make certain kinds of decisions. So you can have two documents, and one of them can say that one person can make decisions about your property, so that, for example, if you are in a coma, that person could cancel your lease because you're moving into a medical care facility, so they could cancel your lease at home. They can deal with the bank. They can deal with or if you still have your home, they can deal with paying the gardener and the cleaner for your home. That person can make all of those property decisions. You can have a separate one for care. So that person could make medical decisions, so that if the doctor is asking a question, would she want this kind of medication? Would she want to be moved into this care home or to stay at home and have a nurse come there? That person that you've appointed as your attorney or representative for care will make those decisions. It can be the same person, or it can be a different person. And so maybe you have a close friend or family member who's better with money, but there's one who's not very good with money, but you trust them to care for you. So it could be two different people. We also recommend you have an alternate person, because once you sign this document, you don't know if you might need it in 1 year or you might need it in 50 years, right? So you don't know if the same person is going to be available by the time that you need it, or if they might decline because maybe they're not feeling well or they don't have the time to devote their attention properly to this. If they decline, they know there's an alternate named who will step in. So you could say appoint, some people say, well, my mother is my primary attorney for care, but my sister is the alternate. Some people say I want to appoint them jointly, so they'll work together on decisions. Some people will say, well, one of them, but they'll consult with the other one. And then for property, you could also have a professional as a backup. So in case your friends or family member that you named first might get overwhelmed, then a professional trust company, for example, could act as a backup. The same thing can happen for your will if you wanted to have a professional trust company or lawyer act as your estate trustee. Sometimes that's helpful as a backup plan, so that you know that you're not burdening your loved ones after you're gone. They might have the choice to take on that role or to decline, knowing that it will be taken care of by a professional.
Who can make a will and who can make a POA? When it's the time to have one done?
Well, I mean, I think for both of them, as soon as possible. Everybody should have them. Even if you don't have a lot of property, you might have pets. So you might want to provide, who will take my cat, who will take my dog, or will it go to the Humane Society? You might want to provide just for just who can deal with the bank, who will pay for the funeral expenses. I mean, it is better to have a will as soon as possible as a baseline, and you can always update it anytime. The same thing with your powers of attorney. You don't know, nobody plans to be in accidents, but they can happen to anyone. So it's like insurance, right? You hope you'll never need it, or you won't need it for a long time, but it's better to have it than not to have it for everybody.
Basically, when you turn 18, you should have a will and a POA for property. And when you turn 16, a POA for care, right?
Well, I got a will and a POA for property when I was 18. We didn't really do POAs for care back then. It was a while ago. But yeah. It's always good to have one as soon as you're an adult.
Yeah, you're right.
So let's talk about what happens if somebody becomes incapacitated. Let's say somebody goes into a coma, a boxer, and they're fighting, and somebody punches them in the head, and all of a sudden they can't make decisions for themselves. What happens if they do not have that power of attorney document signed?
So in that case, probably a family member would have to step in and make an application, which is called a guardianship application. And it would cost way more and take a longer time to get the guardianship. And then if the POA had been made before the accident.
One of the great things about the power of attorney documents is that it gives you options. I mean, same with wills, really, but like, if, for example, if you're elderly and you don't have a lot of family left, or if you have family but they're elderly and you don't want to burden them, for example, then you can appoint a friend to be your estate trustee, to be your attorney for property, to be your attorney for care. And that's something, it wouldn't happen by default. So if something were to happen to you and you don't have any documents, by default, if you don't have family, then the government would step in. The government would manage your property for you, would put you into a care home, but they won't always, I mean, they're busy people. They won't have as much understanding of you and your wishes as maybe a close friend would. So this document gives you the option to specify those wishes. Um, and you could also appoint a professional too. So um, you would be also helping family if you could put a family member first and a friend as an alternate, then your family would know like, oh, well, I have the option to decline because I don't feel that I'm up for that right now. They would have that peace of mind to know that there's another person who cares for you, who would take on that responsibility.
Yes, I agree with you. And another question that clients usually ask is about their wishes regarding medical decisions, especially regarding beliefs, religion. The attorney for care, do they need to respect the wishes, or can they bypass the wishes?
Well, so the binding document is the one that says who will make the medical decisions, but then beyond that, you can make guidelines for that person to follow, but it's not binding on them. So it can be very hard to know in advance what you would want for every possible medical scenario. And so your loved ones, when they see you suffering, may think, oh, let's do something to minimize the suffering, even if it might shorten their life. I mean, that's a decision that that person, they would like to know some guidelines. If you've written guidelines, they probably would want to follow them, but they will still not be bound to them when the time comes, because you don't necessarily know how much somebody's going to be suffering, until you see it. So those are not binding.
Yes, in general, the attorney must respect the wishes and act in their and also act in their best interest. Sometimes, as Audrey put it, the best interest might not be their beliefs, but they have to do everything they can to follow their beliefs, their wishes. I think to finalize, it would be important to explain when a will and when a POA will become effective.
Well, a will become effective when the person has passed away. So you wouldn't need a death certificate to go with that application for appointment as an estate trustee. The POA, for the attorney for property documents, you can specify it can be what we call a continuing power of attorney, which means that that person that you named always has the ability to act as your representative, even if you just go on vacation. Or you can specify that it will only become effective when you are incapacitated. So in that case, there should be a medical assessment saying that you can't make your own decisions, and then once that's confirmed, then the person will be able to deal with your property. For care, it can be just your family doctor can say, oh, I need someone else to make this decision. He's not responding. And that's when that becomes effective. So if that is all of our questions for today, we would like to invite anybody who has further questions or would like to engage in personalized discussions with us to reach out to Nelligan Law. And we'll be happy to work with you to develop plans for your estate, for your end of life care, answer any questions you may have about how to provide for your loved ones.